So good morning to you all, and thanks for coming. This is our Friday thing. It's always a good thing to hear from people you may not hear from at all. Today we have a lawyer, Adam Soliman. He trained here at UBC as a lawyer, right? And then he took off. Law was too small for him. This is the kind of people that excite me, right? So he has all the law, but then he went to land and food systems and did a master's in economics. That was when I met him first. I was on his committee when he did the master's. Then he took off and went and started his own law firm in downtown. See, he likes teaching. We met in India, small-scale fisheries is all over the place, and he's back at UBC doing his PhD. Why? I think you are a natural teacher. You want to be a professor, so welcome to the club as soon as you finish your PhD. So I'm just saying this so you guys know we're interdisciplinary. We love people like this who refuse to be put in a box. You start off and you can do anything. And that's a good example of that. So Adam, welcome. We're looking forward to hear from you about terminology, law terminology for fisheries scholars. Very important subject.
Good morning, everyone. Thank you for having me here. Thank you, Rashid, for the introduction. Thank you, David, for the introduction. Really appreciate it. So I want to add something to the intro. As Rashid said, I was always here at UBC. My journey started back in 2007, and I did a master's in agricultural economics, and I had to find a thesis topic. And I don't know what happened, but I found myself in this building up on the third or fourth floor, sitting in front of Rashid for the first time. And Rashid opens a drawer and says, well, here's a topic for you. It was quotas. It was ITQs. Rashid and Gordon Monroe had worked on a project with Megan Bailey. And it was a report at that time. And my supervisor was in dairy quotas, who told me, like, if you want me to continue to be your supervisor, you have to find a topic that relates. And there you go. Rashid gave me ITQs, and that was my first work in fisheries. And since then, I had not stopped working in fisheries. The second thing is, and Rashid ended up being on my master's committee, and he's actually now on my PhD committee at the Allard School of Law. So that's my journey here with Rashid. But so I started with ITQs. That's where my first, property rights. I was looking at quantifying the risk involved in holding a ITQ quota. Some economics there and a bunch of math. But soon after I switched, I didn't get into my PhD. I switched into law and pursued law, and then I did master's in law, agriculture and food law. But since then, every single assignment I've worked on was in fisheries. And soon on in my master's, they would call me the fisheries resident at the law school in Arkansas. And so I took it on. I kept on publishing and working with research institutions and other places while I started my practice. And because of that, I acknowledge my teachers and mentors who are here and who are not here, and the work I've done with TBTI, Too Big to Ignore, if any of you is involved with them. But over the years, beginning with my master's, I was confronted with a lot of terminology that was confusing. For those who worked in ITQs, individual transferable quotas, know the debates out there, and the ones who are for it, the economists, and the ones against it, and the dilemmas it creates. And from my perspective, starting to study law, all these terms became more important to recognize. So over the years, I've put together a bunch of terminologies that I found to be very important, and I ended up actually giving similar talks in conferences instead of my paper that I'm presenting, to help clarify some of the terms. Although I haven't really published a paper per se on the legal terminology, but this comes from a bunch of work over the years. So I want to so the idea today was to take you through some of these terminologies, and hopefully it would help clarify any or some of the confusions around them. The word rights, that's where the dilemma starts with, rights. A lot of us use the word rights, and it causes a lot of confusion. you can just see from these headings here, when you talk about human rights, you talk about constitutional rights, you talk about property rights, all of these are using the same word, rights and rights and rights. And in fisheries scholarship, these words are usually used in all these contexts without really going back and thinking on or without defining them per se, because legally speaking, they have different meanings. So what I wanted to do is first put a layout of some of where these words get used. So, this looks confusing, but this was actually prepared while I'm sitting waiting to present in a conference in Uganda, and it came out. People liked it, so I kept on using it over the years and adding to it. But it's actually very simple. This is sort of a little layout of where the word rights can fall, and it shows you that it actually has different meanings. So, as you know now, there's a trend in fisheries management to talk about human rights approach to fisheries management. Those who are involved in indigenous fisheries think of indigenous rights as a constitutional right. Others think of it as a customary right. So I just wanted to put this map to lay out where they fall in and what's the relationship between these different types. So if you look at the bottom there, there is the fishers. If you think of these are the individual fishers, and between them, you can have rights. One can lease to the other. That's a right, a leasing right. But then you have the community as a stakeholder. You have the government as a stakeholder. So the area that involves fishermen or fishers between themselves and within the community, if we're talking about community-based arrangement, that all falls with what we call private law. That's a private law, and the rights under it falls in that area. But once you get into rights between the government and the community, or the government and the fishers, that is not private law anymore. This moves into public law, different arena altogether. And when you go up higher in the level, you have constitutional law. So you have some places like Canada where they think of indigenous law as a constitutionally protected law. Okay, what does that mean? This has a lot of definitions to it. There's cases where you have to follow to understand what are those rights exactly, but in essence, they are constitutionally protected. Okay, so I put them up higher there, but that is because they're sort of high level, but that doesn't mean they're actually as enforceable as the lower level private rights. As a matter of fact, in practice, those rights, the private rights, are easier to enforce in court. Yet the constitutional rights are long and expensive court battles to assert the right and to enforce the right. Yet they have this connotation of being a constitutional law, rights that must mean something stronger. In essence, it doesn't actually. We have negative and positive rights. I'll cover that later. They have a slide on its own, but in a nutshell, negative rights are those rights that involve you not to do something, not to infringe on something. Positive rights are rights that must be performed. For example, I can say, you have a right to fish. That's a positive right. You can assert that right. The negative right is you have an obligation not to fish during that season or in that area. It's a negative right. On the right side there, you see procedural rights versus substantive rights. There's a difference again. I have a slide on that. We'll cover those in details and what they mean. I want to come here to the left a little bit. So the other confusing term we see regularly is the customary rights. Customary rights also appear in fisheries literature a lot because we're dealing with places in the world where the word customary means something in their constitution or in their law. Primarily more than Canada. In Canada, we're kind of looking at indigenous rights under the Constitution, but not necessarily as heavy as customary rights in other countries. But in essence, customary rights can be part of the constitution in some countries, but not in every country. International law looks at customary as the traditions and what has been really customary, and it makes its way eventually to becoming the law. So it's sort of a lower level before you move up to being recognized in writing as a law. In other places, customary rights are recognized and they're part of the Constitution, and it's written and it's included already, right? So it again, customary rights vary depending on where you are. We talked about, so that's another term that we see come up in fisheries scholarship. These other two terms here also come up very often: private property rights and common property rights. That's where some of my work have really focused on. Private property rights, we know, are things like ITQs. They're a form of a private property right. And common property right seems to be the rights of a community, which is in a lot of work preferred over private property rights. Private property rights creates a lot of tension in fisheries literature. And I'm going to break that down a little bit more in the next slide. I'm going to move on from this slide, but I'll come back to it because a lot of these terms are being explained later, but I'll come back here and we can show the relationship between all these terms. So where do we promote rights? There is the arena of international law, okay? So you have binding agreements between countries, two countries, bilateral agreement. Two countries can have an agreement on some laws related to fisheries. There could be non-binding agreements, memorandums of understanding, etc. So there's the arena of international law. There's domestic law, and domestic, think of Canada. Where do we have our fisheries regulated? We have it under the Fisheries Act, right? We have that as a law, but we have higher than that, we have the constitutional law, and in constitutional law, we can find the indigenous rights embedded. Interesting enough, because Canada is a federal law, we have Federal Act and we have Provincial Act. So the federal Canadian Fisheries Act is what really governs fisheries in Canada, but a lot of people forget there's a provincial act that governs the sale of fish in the province. And the Fisheries Act usually governs the fishing activities, extracting the resource from the oceans. So you can enforce your right by lobbying inside international law or domestic law. There's government lobbying, and there is courts. You can assert rights in courts, and that's where a lot of the cases go, whether it's constitutional or between private actors. So the court plays a big role, government plays a big role, and you have private contracts, whether it's agreements or leases between two fishers or between an organization and a fisher. That's all private contracts. And then you have informal arrangements where you can enforce some rights through communal arrangements or agreements, or in writing or not in writing, doesn't matter, but it's still an informal setup between parties. Now, when we go throughout all of these methods to discuss a plan that we want to put in place, we often have to talk about the costs, the time, and also the enforcement. A lot of times it's not good enough to just write something. What matters most is how are you going to enforce it? Is it enforceable? So these are factors we consider when we talk about management plans in any of these arenas. So as you, I don't know how many of you deal with the small-scale fisheries guidelines of the FAO. Is that something you're familiar with in your works? Yeah, some of you. So the move towards a human rights approach is sort of embodied in this small-scale fisheries guideline. The term human rights-based approach has been recognized, and the voluntary guidelines of the FAO has been on from, I think it was 2005 or 6? Sorry, 15. 15, did you say? Thank you. So a lot of terms came out of that guideline, and the direction of human rights start showing up. We were, before that, talking about private property rights. Now we have to talk about human rights. So I want to go over, well, I have here on the next couple of slides, I copied over the objectives of the guidelines, but I'm going to step forward slightly and then come back to it. I want to, I want to start with the private property rights first, and then we'll go back to the human rights. This is where a lot of the confusion debate started. A lot of criticism on ITQs came because it's referred to as ownership. It's private property right. Private property right is bad. Legally speaking, lawyers don't look at it as a bad. It's an instrument. It's how you use it and how you customize it to achieve a goal that makes the effects of it good or bad. So if we break it down, you have public property or state property. You have common property, collective property. You have private property, and you have open access. These are the types of sort of property rights acknowledgement in fisheries. But property is defined overall in a very general term as a bundle of rights. It's a bunch of things put together to tell you what is that property. So ownership is one term that has a bunch of rights attached to it. So you can call, or you can say that I own this. So let's think about it this way. You own a house, right? Okay, what does that mean? Well, it means that you have the right to sell it. Well, that's a right, an independent right. You have the right to live in it. That's another right, separate. You have the right to mortgage it. That's another right. It's a bunch of rights put together that makes you consider or think that you own something. A lot of things we own, we don't have full rights to it, right? Or you can have restrictions placed on you to what to do with it and what not to do with it. We all own a laptop, or some of us own a laptop. You can use it to do your work, but you can't use it to write certain words and publish it, right? There's restriction what you can do with it. Same thing here in the context of fisheries. When we say you own a license, you have to ask yourself, is it really ownership? What are the rights under that license? Is it a right to catch fish? Is it a right to sell the fish? Do you have the right to lease that license? Do you have the right to sell that license, right? So in order to say that there's ownership, these things have to be really in place. You have to have the right to possess, manage, and control. You have to have the right to drive income and capital gains from that thing. You have the right to transfer it while you're alive or upon your death, and it has to be protected. You can enforce those rights in court. If you can do all of that freely, then you can call that an ownership of something. Okay, so, but the point is also that it has a bunch of rights under it. The other thing that I was referring to earlier is that when you have certain rights and specifically ownership, it usually comes with duties. So when we say we have a right to this, we always think, okay, what are the duties on the other hand of that right? These are some further types of property rights or proprietary interest. And by the way, a lot of legal scholars, when they start talking about rights, they actually switch to the word interest. That's a more easier word to generalize with from legal perspective. So when I use the word proprietary interests, that's meant to be rights. So we have some distinctions here between the tangible and non-tangible rights. You have a distinction between real property versus personal property, right to have access or exploit a certain resource that's relevant to fisheries, the right to derive profits from what you catch. We have other types of, other types of rights. For example, the right of way, we call that easements. Okay, that's a different type of right on its own, but it's the right of way, the right to go through the body of waters, or the right to go through a road on a land. That's referred to as easements. License is what we come across a lot in fisheries, of course, whether there's a quota associated with license or independent license that gives you full rights. But you have to think about it in segments. ITQs, when they operate with a license and a quota separately. A license could be a permit. It's usually issued from some authority, not necessarily all the time. In private settings, it could be from the group that is giving you certain rights. They can issue a license to your private license. And it's a license to do something that is specified in the license itself. It's like your driver license. It gives you a license to drive. That's what it does. Sometimes it places restrictions, and it will be in that license that tells you what you can do with it. Different categories of licenses. We have a bare license, contractual, licensed by proprietary estoppels. Anyways, different distinctions on types of licenses, and we refer to those sometimes as instruments. We talked about some of the obligations that come on the other hand. So the duties that are created with rights. There's a distinction between positive and negative rights. Negative rights are liberty rights, those which are only require that others not impede your ability to satisfy them. Positive rights are, on the other hand, are sort of welfare rights, required participation of others to enable the right holder to satisfy that right. So one example of a positive right is when you say we have rights to live above the poverty line, rights to feeding a community, or any of those types that we always hear now about as sort of an objective. The problem with the positive rights is that it creates an obligation, and it comes with costs. Where negative rights is just a right to or an obligation to refrain from doing something. And also, when we impose positive rights, we have to also think of when do they get imposed? Is it immediate realization or something that gets done over time? And that again relates to the cost and the efforts required to impose those rights. So we talked about, I referenced earlier, substantive rights versus procedural rights. So substantive rights are things like labor rights, right to work, prohibition on slavery. These are all substantive rights. Procedural rights, on the other hand, is things like right of consultation, fair procedures. They're different type of again, rights. We see that in the context of human rights, mostly. So this is what I've put together on some distinctions and names of property rights, but I want to go now back to the guiding principles of the small-scale fisheries guideline. It embodied all these 13 sort of guiding principles, which we think of now as the constitution, if you will, for human rights in fisheries, the main instrument that really have gathered human rights elements and put it in a guideline for fisheries. So you have things like human rights and dignity, equity and equality, non-discrimination, gender equality and equity, etc. Again, a lot of these involve the use of the word rights and terminology that is often not clear. And a lot of scholars have tried to work around what it means. So for example, there's a lot of work done on gender equality and equity to explain what does it really mean in the context of fisheries. And this is not strange, by the way. A lot of countries even go through that when they set their constitution. Legal scholars go for years and decades to try to understand the words used and to define it further and to put restrictions and to expand on them, etc. So the work that has happened since the small-scale fisheries guidelines came to life was expected. One of the main questions a lot of people thought of and asked was, is it enforceable? Because the name of the guidelines says voluntary, but you have countries like there was Costa Rica that actually implemented the guideline in its own laws, right? Hence made it enforceable, despite it being a guideline, a voluntary guideline. So what the words mean and what are the restrictions applied to them really varies depending on the use of them. So before that, I had put together, I've copied the objectives verbatim from the guideline, but I don't intend to go through them one by one here. So I'm going to go back here to this diagram. So the use of private property rights is actually invoked in a lot of areas here. So I talked, when I started, I said that between different fishers, you can have different rights between them. But nevertheless, private property rights is actually used in a lot more than that context. Common property rights is actually a use of private property rights. It is a bundle of the same rights put together such that it is the community that has the rights or has a right between the community and the fishers in that community. So in one place you can find for example, if we take the quota example, you have the quota assigned to a community, and then the community goes down and divides the licenses or the quotas among users based on certain guidelines and principles they put in place. And that creates rights between the community and the fishers. That can also create right between fishers themselves that hold those quotas. The same set of rights come down from the government, and I'm going to use the word come down from the government in a cautionary way because it's not in all places it's a top bottom approach, but in a lot of places it is. So you can have that award of quota coming from a government to a community. Even it could be through lobbying by the community of the government. So how they got it, and it could be actually coming down from the Constitution requiring the government to certain quotas. So the source of that is really circular. It depends on the context itself, but certain rights are given from government to community to manage a body of water, to manage a sum of quota. and then those rights can be distributed down to individuals or in that community. Now, of course, there's rights between fishers and other users. The other users could be the organizations or individuals that deal with the fish, that sell the fish, the markets, etc. There could be rights between them as well. The word governance, in a legal sense, from what seems to be happening, embodies all of that. When we refer to governance, I'm not talking about the governance work in other fields. I'm talking from a legal perspective. It's all of that, for legally speaking, falls under governance. How it's all set up, analyzing it or planning it is the sort of the governance activity or that happens. We have other terms like tenure and what it means. It's a little bit, in some legally speaking, sometimes it refers to the term, to the time involved in the setup that is in place. In other places, some scholars use it to mean the actual property right itself. They call that a tenure. So it's a little bit confusing term, but it does appear here and there. Yeah, there's also reference to the word absolute right. And that actually causes some confusion. Some people think that when you have a right, it's absolute. So an ITQ, people think that that's it. It's an absolute right. No, absolutely not. There's nothing that is absolute except very few rights, and usually the place for those rights are in the Constitution. And that's like the right to life. Okay, so property rights or any of the lower level rights do not come close to an absolute right. And some of the absolute rights, they have exceptions too. Okay, in some countries, the right to life has an exception. So, and this is important because some people think once they have a right or that assignment of a right, such as quotas or a fishing license, that it's set in stone. As a matter of fact, most of them are not. So here in Canada, we have ITQs come with a precaution that the Minister of Fisheries has the right to make changes to the license. As a matter of fact, it has happened with the halibut quotas here in BC, which led to cases in court. And the court found that the minister does have the right to make changes. And the change there was the percentage allocated between the commercial and the recreational fishers. And the minister made a change, and he was sued, or the government was sued on that change, and it was found that the minister has the right to make a change. And that's not just an example to say that it's not absolute. It's sort of recognized, it's certainly not absolute, but even though the maintenance of that quota itself can be jeopardized. And same thing with a license. Sometimes you issue the license, sometimes it comes with a duration, and you think, okay, they can't change it for those 10 years. No, they can't. Legally speaking, they usually can. What are the consequences? That's usually also known. Sometimes it's not known, and it becomes known after people sue or things like that, and the court has to determine what are the consequences, if there's any. So, yeah, so absolute rights, no, property rights are not absolute. The management schemes can change. They actually can't change so suddenly and abrupt. And this is important. It was important from the work I was doing because the thought against ITQs that it's permanent. The rights are given away permanently, and that's really where I started my work, my legal work in fisheries, to understand that. And yeah, so that's why I throw that term here as well. There's also an overlap between the court, government, and parliament that needs to be recognized. even if the government issues, or the parliament and government issues certain scheme, the court has a role. It's often overseen and not discussed in fisheries work, but the court ultimately makes certain decisions, and it has, even in Canada. And we usually don't think of it that way, that it has a role, but that's where all the cases that determine the meaning of things and the rights come from. I'm going to move quickly in the last 10 minutes we have here to another area where there's some confusion on terminology, but I apologize because I'm not going to give it enough time it needs. And I realized that today when I was preparing. Yeah, so gender is one of the topics that I just looked at it in the small scale fisheries guidelines. And I put together a few slides for you here for those who are interested in this topic specifically. It's a new area I moved on to a few years ago. And this is the title of a paper I published on this topic. I'm still doing work in this area, but the idea in this paper was to come and look at gender equality. There are scholars in fisheries that have worked in this topic, but what I found also from the legal terminology perspective, there is a sort of a general one understanding of seeing come up in most papers. And that's what, when I was looked at it and I realized, okay, we have a whole body of work in feminist legal theories that could be very relevant to fisheries and fisheries scholars. So I did a paper on it, and here I'm summarizing some of that, the relevant terminology. What I'm going to present to you here is a bunch of theories, feminist legal theories, to show that actually gender equality has more than one meaning, more than one approach. The general approach that I've seen, here's an example of it, a definition used in a paper. Some of you might recognize some of the authors, especially Kleiber. This is a definition was used in a paper published in 2017. Gender equality usually pertains to the creating of or the outcome of equal opportunities for women and men by removing formal barriers. In the small-scale fisheries context, this would mean changing policies that exclude primarily women from equal access to fisheries jobs, markets, and other resources. It can be thought of as an outcome of efforts to create equal opportunities. That was the definition chosen in that paper, in the Kleiber 2017 paper. Feminist legal theory offers a multiplicity of approaches to gender equality. There is a sort of a high-level distinction between two slits, a symmetrical approach and an asymmetrical approach. There's two models under the symmetrical approach, assimilation model and androgyny model. And under the asymmetrical approach, you have three different models. The difference between those two groups is one looks at equality in sort of in its literate mean. The other looks at it with acknowledgement of differences. They both fall under equality, but they're two different approaches. So I have here sort of a snippet of what I had in that paper of what these two mean with cross-reference to the page number, if anybody is interested to go read more and more details about these models. But for the time we have here, I'm just going to go over those 5 models very, very quickly. Assimilation and androgyny are those who models that look at gender between whether the men and women should be treated equally, barriers should be removed so that the laws treat each the same. The other models that looks at differences, so you have the special rights model. It affirms that women and men are different and asserts that cultural difference must be taken into account. So also cultural differences are taken into account into the special rights model. Society must ensure that women are not penalized for those differences. The accommodation model allows for differential treatment in certain cases. It also addresses cultural and hard to classify differences. And The acceptance model does not necessarily consider sex difference problematic. However, it focuses on eliminating the unequal consequences of sex differences and considers to be more important than debating whether such differences are real or even trying to eliminate them altogether. The empowerment model, it has this sort of overall claim that subordination of women has itself constructed the sexes and their differences, and that we should forget about the question of difference and focus directly on the subordination and domination. So it really approaches domination as the main issue. So as you can see here, there are many models of gender equality. They come from the feminist legal theory, something that I've not seen in fisheries scholarship almost at all. I did a lot of search to find everything that was written on gender equality that relates to these theories, and I couldn't find. So that's where this paper came in place, sort of an opportunity to expand beyond a one model or one idea of thinking of equality. There are other models other than those two groupings. There's equal treatment versus special treatment. There is sameness and differences. The dominance models. But if anybody wants to get more into this or read a little bit more, I put the citation here for the paper. It's part of a book by referring to Blue Justice, a bunch of authors, including the group out of TBTI that put together, and that's where I published this paper. So sorry, I had to run you through a lot of terminology. I assure you, I can be spending hours talking about terms, legal terms, but I try to put together what I've seen to be the most relevant to some work coming out of fishery scholarship. And I'll leave you with that and take questions that you might have.
I'll read it out. Could you tell us a little about the definition of rights in the context of international negotiations, when some countries have disparities in the definition of property rights, for example? The latest tension between China and the Philippines.
Thank you. Yes, every instrument that you rely on will have an issue on definitions. So if you look at domestically for an act, like you pick up any act, the Fisheries Act or any other law, a lot of times you find a section for definition defining terms. But on the other hand, a lot of other times they don't have, and you have to go fetch for them. In common law jurisdiction, like Canada, US, UK, New Zealand, and Australia, that's actually a common exercise that legal experts go find. So what does it mean to say license? A lot of times that comes down to a judgment. The court will say, after having heard the lawyers, this is what this word will mean in this context, if it's not written in the law. Civil countries usually are better at defining those terms. So for international agreements, the same thing applies. When you have an international instrument, you want to be able to understand the terms being used. And if the first place we look at is the international instrument itself, and if we don't find the meaning there, then we go look at cases. For international agreements, you can go look at WTO cases, for example, and that's where we get meaning of definitions from. And if we don't find definitions there or meanings of words there, then it's up to legal scholars to make arguments. And if there's a conflict between two places, well, until it's settled by agreement or settled by an adjudicator or a body that has the ability and the right to make those decisions, it will remain a debate. And this is actually one of the biggest things we do as lawyers, work on the words. And believe it or not, this is not, you think that a lot of words are settled. They are not. They are not. So yes, we resort to the adjudicator to decide on conflicts on the terms. And even if they are defined, sometimes your application of the term causes confusion. And you say, okay, well, in this situation, this is different. Again, who decides? It's either the parties by agreement or the adjudicator. So hopefully that answers the question. I know it's in the context of international law, but it's actually the same, whether it's international law or domestic law.
Yeah, thank you. Thank you. Now the mic works. Thank you very much.
Thank you. Yes. Oh, Rashid Sumaya is asking or giving an example of the word is. It creates confusion or arguments for lawyers to make, and that is true. We argue a lot about all these little things because they mean a lot, and and or is another thing we fight over, and because one includes and one excludes. So is he liable or not liable? Do he has to pay $1 million or not? Thank you very much. So this question says is asking about the obligations and whether obligations are included and defined when the rights are defined. Most often not. So I'll give you an example. Fishing rights can come out of the Fisheries Act. It tells you what you can do, but what you can't do is in the Criminal Act. That's very common in Canada, for example. So you get almost a complete separate places of where they fall. So the criminal code would tell you what is illegal in that terms, but yet the Fisheries Act doesn't mention it. I'm using that very lightly, but it's to show you that often they're not included. A better place to include it is the same place, of course, when you're writing something, but a lot of times they're written either in a without complete information. That could be as far as common as the law itself when it's written out of Parliament. It could be incomplete and without proper assessment. That's why some laws get invalidated by the court as unconstitutional, thrown out altogether. So you can imagine when you want to write something as specific as fisheries, how many scholars you want on that committee to write and think of all the cases for it to be better and to include not only the rights, but also the obligations.